Okay, so we'll give it a few minutes as people are able to hop on. We'll just give that a few seconds and then we will get started here shortly. All right. Okay, so people are filtering in. So thank you everyone for joining. My name is Brittany Maddox. Welcome to session 2 of the Ability Center of Greater Toledo's ADA seminar series. This is promoting housing justice from barriers to full community access for people with disabilities. It's co-sponsored by the Fair Housing Center and put on as part of the Ability Center's Access Network. And I am here today to introduce our next speaker, George Thomas. Just a few housekeeping notes very quickly. This session is the second of 6 over the next 2 weeks. And if you haven't already, we recommend that you take a look at the seminar website, which will be in the chat with the full lineup. And we will drop that a few times throughout the presentation today so that everyone has access to that website. Our sessions are being captioned and you can click the bottom button of your screen and you can enable captions on Zoom. Because we've been approved for CLEs, we will be giving polling questions every half hour. So when one appears on your screen, answer the question and then we will move on with the session. So today's session is titled Accommodations and Modifications, the Rights of Persons with Disabilities under the Fair Housing Act and How to Enforce Them by George Thomas. George is a 2007 graduate of the University of Toledo College of Law. George's practice focuses on nonprofit legal services, particularly in the areas of housing, landlord-tenant, fair housing, and other civil rights laws. George serves as the Vice President and General Counsel for the Fair Housing Center, where he oversees litigation, administrative cases before the Ohio Civil Rights Commission, and a landlord-tenant mediation program. George also frequently works on local housing policy, advocacy, and research related to the Fair Housing Center's mission. And with that, I will go ahead and turn it over to you.
Thanks so much, Brittany. And the Fair Housing Center is really excited about this seminar. Very happy to be here and to co-sponsor and co-organize the seminar. And this is a very, very important topic we'll talk about today. We're going to do an in-depth review of reasonable accommodation and modification requests. That's going to cover all aspects of it. And I'm particularly excited about this because most of our cases here at the Fair Housing Center are actually persons with disabilities contacting us seeking assistance. And one of the most common types of cases that we handle are reasonable accommodation requests or reasonable modification requests. So let's dive right in. That's me and my contact information too. If you'd like to contact me after the presentation for any reason, to ask additional questions or review anything, I'm happy to receive those kind of calls and inquiries. Just to briefly explain too what the Fair Housing Center is. So the Fair Housing Center is a private nonprofit community resource dedicated to the elimination of housing discrimination, the promotion of housing choice, and the creation of inclusive communities of opportunity. So the way we accomplish that, the activities that we provide for our community are advocacy for anti-discriminatory housing policies, education and outreach for consumers, the housing industry, and the public. So that includes this event, like ADA seminars like this and other events that we often do in the community. One of the most important things we do too is enforcement. We investigate complaints for folks who contact us saying that they feel that they've experienced housing discrimination. We pursue litigation, administrative complaints. We also do research in the Fair Housing Act and to look at ways that the housing industry may be violating the Fair Housing Act. And we also enable local governments to fulfill their fair housing requirements. Local governments, if they receive community development block grant funds or other funding from HUD, are required to affirmatively further the goals of the Fair Housing Act. We don't have time today to get too far into that, but that's an important requirement that local governments have if they're receiving certain types of federal dollars. One of the other things that the Fair Housing Center has started to do more recently is provide landlord-tenant mediation services. We get so many calls from folks who are experiencing housing issues. They might not always involve housing discrimination. They involve other issues like disputes over housing conditions in a rental unit, for example. Well, that's where our landlord-tenant mediation program can also come in to try to help folks reach an amicable resolution between the landlord and the tenant to resolve other issues that are not necessarily housing discrimination. So what we'll be talking about today is one, the basic concepts of, so that everyone's on the same page of what fair housing is and how that works, the Fair Housing Act functions. We will also then jump right into reasonable accommodations, which are changes in policies of a housing provider. And then we'll talk about reasonable modifications, which are physical changes to a housing unit in some way. And then finally, perhaps the most important part is that we'll talk about the practical aspects of processing a reasonable accommodation or modification request. So both from the perspective of someone who wants to make the accommodation or modification request, but then also thinking about it from the perspective of the housing provider who wants to make sure that they're in compliance with the Fair Housing Act. And of course, that last part will be particularly helpful for folks who may be representing, or attorneys who are representing either a tenant making the request or perhaps the housing provider who's thinking about what the best way to process a request or what policies to develop to make sure that they're processing reasonable accommodation requests effectively. Okay, so let's jump right into the part one. First of all, just at the basic level, the term fair housing means freedom of housing choice, the right and ability to choose where one wants to live. It means everyone in our community should have equal access to housing opportunities. And of course, that's particularly important for persons with disabilities, as they may need accommodations or modifications to be able to access that true freedom of opportunity in housing. Now, housing discrimination means denying or limiting housing choice or treating someone unfairly because of their protected class. Only non-discriminatory factors should be considered to determine eligibility for housing, for example. So if you're determining eligibility for housing based on, let's say, race, color, or disability, that might be a form of housing discrimination. And all facets of the housing market are covered by the Fair Housing Act. Those include lending, appraisals of housing, insurance, rental, sales, design and construction of housing, and advertising. So the Fair Housing Act itself is a relatively short document, but it covers almost every aspect of housing, and that certainly includes questions around accessibility and discrimination against persons with disabilities. So protected classes under the Fair Housing Act are classifications of groups protected by and specifically enumerated in the Fair Housing statutes. Everyone that is listening to this program and everyone involved is a member of a protected class. So everyone is in some way protected under the Fair Housing Act. Recognized protected classes are listed on the screen now. So of course they include ones that most people would recognize or think of as a protected class. It includes race, color, national origin, religion, sex. Other protected class, perhaps not everyone is familiar with, is familial status. That basically means families who have children or the absence of children. If you're screening tenants on that basis, that could be a violation of the law. Of course, I hope the folks listening in now recognize that disability is a protected class. There's also protected classes that are not necessarily recognized in the Federal Fair Housing Act, but they may be recognized in state law or in perhaps local municipal law. So in Ohio, for example, Ohio recognizes military status, whereas the federal law does not recognize military status as a protected class. Ohio law also recognizes age as a protected class in the lending industry specifically, as another example. Some examples of locally recognized protected classes include in the Toledo area, as well as Bowling Green, sexual orientation and gender identity. Now, I should say that after the Supreme Court's Bostock decision, at the federal level, sexual orientation and gender identity are now recognized, and HUD will pursue claims based on those protected classes. The thinking with that, though, is that it's covered within the protected class of sex, according to the reasoning of the Supreme Court in Bostock, and now HUD has recognized that. I'm just saying that in addition to that, the city of Toledo has more explicitly recognized in its local law that sexual orientation and gender identity are specifically recognized as a protected class. Also, source of income is recognized as a protected class in many cities and states across the country. That includes in the Toledo area, Toledo, there's other cities all across Ohio that have recognized source of income. Basically, what that means is that someone should not experience discrimination based on the source of the income that they would be using to pay for the housing. So, for example, let's say you receive Social Security disability as your source of income to pay for your housing. Well, you shouldn't experience discrimination because that's your source of income. Or if you receive a housing choice voucher as your source of income to pay rent, you also should not experience discrimination simply because you're paying rent with the voucher. And of course, that could be particularly important for persons with disabilities who often use an alternative source of income, perhaps other than employment or in combination with employment to help pay for their rent. Finally, Toledo also recognizes immigration status. Of course, national origin is recognized at the federal level, and then Toledo more specifically also recognizes immigration status as another protected class. It's worth pausing for a moment on source of income protection in this context, because as I said, it's perhaps more likely than not that persons with disabilities may use a housing choice voucher or other alternative sources of income to pay for housing. So housing providers must consider all legal, reliable sources of income, such as Social Security, disability, military benefits, and housing choice vouchers. So what that means is that an advertisement like "no Section A accepted here," that would violate such a source of income protection law, which, as I've mentioned, are becoming more and more frequent and are in cities all across Ohio and across the country. Now, of course, tenants are still required to pay rent and fees in full, and tenants will still have to meet the housing provider's other eligibility criteria, which could include proof of income. So we might have to show that they have that income. It's just the source of the income that's subject to such a protection. Also, I'm going to touch on a few different very basic levels of fair housing. So again, we're still in the outline of helping you understand how fair housing functions generally before we get into accommodation and modification requests. But one of the things that the Fair Housing Act covers is advertising provisions. Advertisements should describe the amenities or attributes of a property and refrain from indicating a preference for a particular type or individual. This applies to written or oral notices, includes print and online ads, signage, and verbal communication. Discriminatory statements in advertising for housing are specifically prohibited. So, for example, what if a ad said able-bodied only, or what if it said proof of employment are required? Well, obviously that first example seems outrightly discriminatory against persons with disabilities. The second example could also certainly violate the Fair Housing Act because it's maybe more likely than not that persons with disabilities may not be used some other form of income besides employment to pay for the housing. And it shouldn't be a requirement that you'd be employed to obtain the housing. It should just be a requirement that you're able to pay for the housing in some way. Another concept to understand is steering. So directing buyers or renters to certain neighborhoods or areas of a housing complex or a particular neighborhood area, let's say, based on the protected class. So this might include discouraging any person from viewing, renting, or purchasing a particular dwelling, exaggerating drawbacks or failing to inform any person of desirable features of a dwelling, neighborhood, or community, telling a person with a disability that the property is not safe for them, or advertising that they should live in some other setting like a group home or a nursing home, requiring tenants with disabilities to live on the first floor. Those are examples of a way of pushing that person based on their protected class toward a particular area or part of the housing complex or a different housing opportunity entirely. Those would be examples of discrimination under the Fair Housing Act. Another thing to think about too is in the application and screening process. So the criteria to be used to determine whether an applicant is qualified should be objective and consistently applied. Criteria should be based on whether the tenant can afford the property and not pose a direct threat to other residents or the property. Criteria that could be considered might include generally income, credit, criminal history, and rental history. An example of something that would be perhaps inappropriate is similar to the other examples I've provided, is refusing to accept Social Security disability income as income. Another basic concept to consider is the terms and conditions of housing. So a lot of the examples I've given so far are perhaps just directly denying the housing or steering the person to a different housing location or a different housing opportunity. But the Fair Housing Act also covers just the terms and conditions by which the housing is provided. So it's beyond just denying or steering the person away, but the terms that are used to provide the housing. So the terms and conditions should be consistent for all tenants, and variations based on the protected class could be discriminatory. So for example, limiting the use of a pool or exercise room or common area, those could be forms of discrimination. Or refusing or delaying responses to requests for maintenance based on the protected class, or charging a higher security deposit, for example, based on some protected class. Those all could violate the Fair Housing Act. Another area that's covered by fair housing law is harassments and threats of intimidation. So harassment could include negative actions that are taken because of someone's protected class. It might not necessarily be outright denial of the housing, but just making things more difficult for the person in some way. They could include derogatory language, slurs, graffiti, or other property damage, threats of harm, restricting access to amenities. It can occur between housing providers and tenants, or even between two tenants. Let's say one tenant is harassing another tenant based on a protected class. Well, there's case law that says that the landlord has some obligation to take reasonable steps to address that kind of harassment if it's harassment based on a protected class. Another area that's covered is sexual harassment. Sexual harassment is a form of sex discrimination. So as I said earlier, sex is a protected class. So harassment based on sex, of course, would be covered as well. It involves unwelcome sexual advances, requests for sexual favors, or other verbal or physical conduct of a sexual nature. One way that occurs is called quid pro quo, which means offers to exchange services like rent, repairs, or the housing itself in exchange for sexual favors. Of course, that would fall into the realm of sexual harassment and would violate the Fair Housing Act. Renters with disabilities may be more vulnerable to sexual harassment housing. For example, if they need a reasonable accommodation or modification and the landlord withholds approval or conditions things on sexual favors. Disability. So the definition, individuals with a physical or mental impairment that substantially limits one or more life activities. So I've been giving you a number of examples so far of discrimination in housing based on disability, but it's important to understand what we mean when we say that. So individuals who are regarded as having such an impairment are also included within that definition. And finally, individuals with a record of having such an impairment are also included in the definition of disability. The point here, though, you should take away is that the definition of disability is very broad. A lot of different things could be included within that definition. It's a physical or mental impairment that substantially limits one or more life activities. Of course, it's impossible to list all the potential things that could fall within that definition. It's quite broad. Disability does not include, it's helpful to point out, juvenile offenders and sex offenders. While the Act does protect persons who are recovering from alcohol and substance abuse, it does not protect persons who are currently engaged in the current illegal use of controlled substances. So just to make sure that's clear, if you're a person recovering from substance abuse, you have a disability within the meaning of the act. But if you're currently using that controlled substance, that would not be protected under the act. Another thing that's not protected is this idea of a direct threat to the health or safety of individuals or result in substantial physical damage to the property. So if someone's engaging in a direct threat to persons or to property, that activity would not be considered protected under the act. So trying to wrap up this first part of the discussion to give you this general sense of disability discrimination and how the Fair Housing Act functions before we get into the details of accommodation requests. I'll show you a short video. It's actually a client that the Fair Housing Center helped with a disability discrimination issue. Sorry about that, got paused.
Great, when I first moved over here, I was so happy. I could go outside and look at the earth. And when the sky turned blue or yellow or red in the morning, I'm like, wow. But a couple weeks later, not too good. Something tell me it's gonna be some trouble with the Hornets. And one day she asked me a question. How long have you been hollering here? I told her, I said, all my life. That's when she called me names. Dumb, stupid, retarded. I said, I'm hard of hearing, and this is how I talk. She said, well, the people that hard of hearing people do not belong here. They belong in a nursing home. I was angry. I was hurt. I said, just because I'm hard of hearing, that don't give you a right to call me names. But I kept on building up. Told my family members, I'm not allowed to have company. Told the pharmacy, oh, I don't live here. She abused her authority. The manager and the company did nothing about it. I got fed up with it. I said, no, I have my right to live in this building just like everybody else. So I took all my evidence, I take my complaint to the Fair Housing Center.
She was the one that was harassing you, and she also denied people access to your apartment who were coming to visit you?
Yes.
No, you're still living there, right?
Yeah, they want me out, but I won't let them. Out of this case, I want them to realize what they did wrong. I just want somebody to look at me as a person, treat me right the way I want to be treated. I'm a human being. I don't look at myself as a disability. I look at myself as a person. It made me feel like I have the power to stand up for myself. I'm gonna stay on my ground because I'm gonna keep on fighting.
If you believe you may be a victim of housing discrimination, contact your local Fair Housing Center or call HUD's Housing Discrimination Hotline at 1-800-669-9777. Remember, unless you report it, it won't stop.
All right. So the next part we'll be heading into is detailed discussion about reasonable accommodation requests. But before I do that, I'm actually going to pause for just a moment to take a look at a couple of the questions that were entered so far. And I should remind everyone that as we're going along, you can enter questions into the Q&A if you'd like to. So let me address a couple of those. One is the steering clauses seem to become a double-edged sword. I can see why now realtors don't allow searches or modified homes on their web marketing collateral. They are likely concerned about violating the Fair Housing Act. Another question was, why do mods adversely affect home appraisals and home value? I'll address the first one. so I hope that there isn't any, steering occurring in advertising or other things that realtors engage with. I'm glad to highlight that term realtor, just because historically in the past, it may be the real estate industry or realtors who might engage in steering in some way. Some of the classic case examples of violations of the Fair Housing Act would involve a real estate agent who, when they're working with, like, let's say a Black home seeker, would take them only to certain neighborhoods. And when they're working with a white home seeker, they would take them to different neighborhoods. That would be an example of steering. Hopefully that doesn't occur, in the advertising or online marketing as well. But it's important that folks in the real estate industry avoid any kind of practice that could be seen as steering. Another question is, why do home mods adversely affect home appraisals and home value? Well, I guess I would respectfully disagree with that. I think that very often home values could increase actually if there have greater accessibility. And a lot of times I believe there's been some studies done that even reflect that increasing accessibility within a community actually ends up adding a lot of value for home seekers. So next up, we'll go into reasonable accommodation requests and the details of those. So what are reasonable accommodation and modifications? Well, this is really important because reasonable accommodations and modifications are widely available. Like we said, the definition of disability is quite broad. A lot of people could fall within that, and they're entitled to these very powerful rights to ask for changes from the housing provider in policies, that's accommodations, or changes to the physical environment of the housing, that's a modification. So specifically, reasonable accommodations are changes in rules, policies, practices, or services. Examples of that would include creating a reserved handicap parking space, allowing an assistance animal when pets are otherwise not allowed, or requesting a ground floor apartment unit at the housing complex. Example of a modification would be structural changes to the premises to make it accessible. Examples might include ramps, grab bars, widened doorways, lowered kitchen counters and cabinets, or levered door handles. So the point here is that the word accommodation is generally referred to as policy type changes or changes in amenities in some way that generally don't cause a physical change, whereas modifications are the physical changes to the property. And there's different rules that apply to those two different categories. So under, this is a specific law section I'm giving you. This is part of the Fair Housing Act. Under 42 U.S.C. 3604 F3B, reasonable accommodations must be made in rules, policies, practices, or services when such accommodations may be necessary to afford a person with disabilities equal opportunity to use and enjoy a dwelling. And the law very specifically says a refusal to make a reasonable accommodation as mandated is discrimination, which prohibits disability discrimination in housing, sales, and rentals, and in the terms and conditions, privileges, and services there too. So point here is that the law is very clear that a refusal to accommodate a person after they've made an appropriate request could result in liability under the Fair Housing Act. So here's a few examples. So a tenant with severe arthritis makes a reasonable accommodation or / modification request for accessible cabinet handles and door handles throughout her unit. That could be a good a request. A tenant with a mental disability makes a reasonable accommodation request for a single family home. So in other words, let's say a housing provider has multiple different housing units across their portfolio, and they would like to request a unit that's specifically intended for, specifically as a single family house, so they wouldn't face as many disruptions or interference from other tenants. That could be an effective accommodation request. A tenant who requires the daily use of bulky medical equipment may make an accommodation request to be moved to a 2 or 3 bedroom unit. Those kind of requests are actually not uncommon. Let's say someone has a lot of medical equipment with them, they could request a housing unit with an additional bedroom that would allow them to keep some of that equipment. Tenant makes a reasonable accommodation request to move near a medical provider where she receives treatment several times a week. Again, this might be a hypothetical where the housing provider has a number of different units across the city or in different geographic areas of a city. And perhaps the tenant could ask that they be moved to a location that's closer to the medical provider to help accommodate their disability-related need. So let's pause for a moment so you understand the elements of a claim for discrimination based on refusal to provide an accommodation. What I mean by this is that in order for this person to be successful in court, or when they're filing a complaint, let's say with HUD or the Ohio Civil Rights Commission, the person pursuing the claim has to meet each of these elements that are listed on the screen. And we'll go through those one at a time to make sure that you're understanding accommodation requests clearly and thoroughly. So to prove that a housing provider failed to reasonably accommodate a disability, the plaintiff, meaning the person who's making the claim, must prove that 1, she suffers from a disability within the meaning of the Fair Housing Act. Remember that definition of disability that I gave you previously. The tenant knew or reasonably should have known of the disability. The requested accommodation may be necessary to afford an equal opportunity to use and enjoy the dwelling. 4th, the accommodation is reasonable. Reasonable is a key term in this. And 5th, the defendant, meaning the housing provider, refused to make the accommodation. So let's go into a little more detail with those. Before we get into like each of those different elements, one thing to make this whole picture clear is a couple of points. First, accommodation requests are very case by case and fact specific in nature. So just to give you as one example, a case of Anderson versus City of Blue Ash. The case involved an accommodation request to a city to allow a miniature pony at a residential property. So in that case, the person had a disability related need to have a miniature pony specifically at their property. That was very fact intensive and case specific, that person had a specific and unique need to have a miniature pony. And the court had to examine to make sure that they met each of the elements that I just listed for that particular situation. The second important contextual point to understand here, there isn't a need to prove intent to discriminate when we're talking about reasonable accommodation requests. This is a very common misunderstanding from housing providers, and indeed even with for persons who are making accommodation requests. If the housing provider refuses to comply with the request in a way that violates the law, there's no need for the plaintiff, the person making the claim, to prove intent to discriminate. That's different from many other types of discrimination claims. So normally the plaintiff, the person making the claim, would have to have a strong showing that there was some kind of intentional discrimination. Maybe they could show that from statements that the housing provider made, or from a large amount of circumstantial evidence they could prove, that there's intentional discrimination. But when it comes to accommodation requests, the question is just, was the request reasonable? Does the plaintiff meet those elements that I listed? And did the housing provider illegally deny that request? There's not among those elements any kind of need to prove intent. So with this question of whether the person suffers from a disability, I previously gave you that definition of disability. Just to reiterate that one more time, it's any physical, mental impairment which substantially limits one or more of a person's life activities, a record of having such impairment, or being regarded as having such an impairment. Those last two, by the way, are important to note because that means that you might not even have to specifically show that you actually had a disability that substantially limited a life function. If you just had a record of having that impairment, or let's say the housing provider just regarded you as having such an impairment. Maybe the person does not even have a disability at all, but if they're regarded as having a disability by the housing provider and they face discrimination because of that, it could still meet the definition of disability for purposes of the Fair Housing Act. The other question that comes up is the second element that let's say is the defendant knew or reasonably should have known of the disability. So to illustrate this element, let me give you an example. In the case of Jankowski, the plaintiff suffered from multiple sclerosis. They sought a specially designated parking space at an apartment complex. Now the MS, so they experience severely limited their life activities. No question that they met the definition of disability, but the condition varied from time to time. And the person with disabilities often tried to appear as if they were not disabled. The defendant, though, knew of the MS, but they did not believe that the person was sufficiently incapacitated to warrant a special parking space. The defendants did not seek additional information from the person suffering from MS regarding the extent to which his activities were limited by the disease. And so there's a question in this case of whether the person with disabilities really, if the housing provider knew that the person had disabilities, if it was unclear to them to the extent by which like the MS actually limited their life functions. Well, one of the important rulings for that case was that if the landlord is skeptical of a tenant's alleged disability or the landlord's ability to provide an accommodation, it's incumbent upon the landlord to request documentation or open a dialogue. So in other words, if someone approaches the housing provider and says, I have a disability and I would like to request an accommodation, if the housing provider doesn't believe that for some reason, the obligations on the housing provider to ask for some documentation, which we'll talk about a little bit more, or open some kind of dialogue about them. Third element, the requested accommodation may be necessary to afford an equal opportunity to use and enjoy a dwelling. Let's make sure we understand what that means. So the necessity element mandates a causation inquiry that examines whether the requested accommodation or modification would redress injuries that otherwise would prevent a disabled resident from receiving the same enjoyment from the property as a non-disabled person would receive. In other words, necessity functions as a but-for causation requirement, tying the needed accommodation to equal housing opportunity. So sometimes we refer to this as a requirement for a nexus between the disability and the requested accommodation. So in order for the person to equally enjoy the housing unit, do they need this accommodation? That's the basic question for purposes of this element. And a lot of different things could fall within that, but the point is that the plaintiff, the person making the claim, needs to be able to show that connection between the disability and the need for the accommodation. Another important element, the fourth element, is that the accommodation is reasonable in some way. So reasonable just means feasible, practical modifications must be made, but extreme, infeasible modifications are not required. An accommodation is reasonable when it imposes no fundamental alteration in the nature of the program or undue financial and administrative burdens. Generally, courts agree that the targets of the accommodation requests may have to shoulder certain costs, so long as they are not unduly burdensome. The point here is that when you're making the accommodation request, it does need to be reasonable, but there's a lot of different things that could fall within the realm of reasonable. And in fact, the accommodation may cost some amount of money even for the landlord or the housing provider to comply with, but that's okay as long as it stays within this general framework of reasonableness. Again, that the contextual point is this is very fact specific. It's a very case-by-case inquiry to this question of whether or not the accommodation request is reasonable. Fifth, you have to be able to show that the housing provider refused to make the accommodation. So you've shown those other first four elements, and of course you have to also show that the housing provider ultimately did refuse the accommodation request. So one thing that's note here, usually this is very easy to show, they either granted the request or they didn't, but sometimes an issue comes up of what if the housing provider simply fails to respond or fails to respond in any kind of a prompt manner. It could be that the person making the accommodation request is given the runaround or told we're considering things for a very long period of time. Well, there's guidance from the U.S. Department of Housing and Urban Development and the Department of Justice that says a provider has an obligation to provide prompt responses to reasonable accommodation requests. An undue delay in responding to a reasonable accommodation request may be deemed to be a failure to provide a reasonable accommodation. So in other words, if you're a person making that request and the housing provider is giving you that pushback or delay over a long period of time, it could be that you could interpret that simply as a denial of the request, which would meet that fifth element of the claim. So let's touch on a few specific issues here that are helpful to give you like a few examples of areas that come up that sometimes there's confusion around, or people perhaps don't understand that you can make an accommodation request. I hope by now you've realized that the scope of this is very broad. Definition of disability is broad. Definition of reasonableness of the request is very broad. As there's a lot that falls within the potential scope of reasonable accommodation requests. Well, one of those things that falls within the scope are certain adjustments to financial requirements. Those are certainly on the table for an accommodation request. So for example, if the person is using an alternative income source, the applicant for housing or the person who's currently living in housing wants to use an alternative income source to pay for the housing, that may be something that they could ask a reasonable accommodation request for. So, for example, in Shaw versus Habitat for Humanity, there was liability for denying the defendant, there was a disabled applicant sought to meet housing provider's financial requirements with alternative income sources, and the court did find that there could be liability for the housing provider's refusal to grant that request. Another example that comes up sometimes in the disability advocacy realm is the need for a cosigner. So it could be that there's a disability-related need for the cosigner. If that's the case, again, the person may make a reasonable accommodation request to allow for a cosigner, even where the housing provider normally has a policy that does not allow for a cosigner. Another example is the waiver of certain types of fees. So sometimes this will come up in the need to waive a late fee or penalties. Let's say, for example, the person, because of their disability, receives a Social Security disability income, and those payments for that income come at a later date than the due date of their rent. Well, they could ask for a different due date, or perhaps they could ask for a waiver of certain late fees because of the fact that they received that income at a later date because of their disability. Just another example of a potential for adjustment of financial requirements. Another issue that sometimes comes up and sometimes there's confusion around is, can you ask for an accommodation in the context of an eviction? Let's say that a person with disabilities, maybe the housing provider is threatening them with eviction. There's a question of, can they ask for a reasonable accommodation in order to avoid the eviction in some way? Well, there is case law that shows that yes, you can do that. That is certainly an area that's subject to a potential reasonable accommodation request. So in Roe, for example, the citation for which is on your screen, the court held that an apartment complex could not evict a tenant with mental health disabilities based on even on his threatening behavior towards other tenants until after the housing provider had made reasonable efforts to accommodate that disability. The act requires the defendant housing provider to demonstrate that no reasonable accommodation will eliminate or acceptably minimize the risk he poses to other residents before they may lawfully evict him. But the point here is, if you're thinking about this from the perspective of the housing provider, is if you receive that kind of accommodation request, you have to take that seriously. You have to think of some way to accommodate that person and avoid eviction if it's true that the disability may be linked to the need to evict the person or accommodate that person in some way to avoid eviction. Another question that sometimes comes up is, what about past convictions? Well, obviously, it's very common that housing providers will have screening protocols that will try to screen out persons with a criminal history in some way. But what if that criminal history, though, was related to that person's disability, whether it's a mental health disability or otherwise, perhaps they committed those past crimes because of a disability. That raises this question of whether the applicant for housing could request an accommodation to as a different policy for reviewing their criminal history that does not look at that particular crime that was related to the disability. Well, courts are mixed on this issue. Some courts will say that that could be subject to a reasonable accommodation request. And there's another case where the court says that they did not think that could fall within the scope. The point, though, is that housing providers should still take those kind of accommodation requests seriously and consider whether they can accommodate that person by reviewing their criminal history in a different way, if indeed those past criminal conduct was related to disability in some way. Another very common topic for accommodation requests is a no pets policy. I've spent a few slides on this. So no pets policies may affect folks who have a person with disabilities who needs an animal in order to accommodate their disability. And HUD has even issued very specific and detailed guidance on considering accommodation requests related to animals and changing no pets policies so that persons with disabilities can still have a service animal or emotional support animal, or an animal that's in some way assisting them with their disability. The link to the most recent guidance is provided on the screen, but you can also just simply find this by Googling, HUD guidance on assistance animals, and then notice that was provided in 2020 as the most recent guidance from HUD. So the first thing to mention when it comes to no pet policies is that certain types of service animals should be very easy to process for an accommodation request. So if the person, let's say, has a readily apparent disability and is relying on a service animal to accommodate that disability, then there really should be very little that that person has to do to receive an accommodation to the no pets policy in that instance. Let's say hypothetically, there's an applicant for housing who's, let's say, a person who's using a wheelchair, and they have an assistance animal that's very clearly helping them with the tasks in some way when they go to apply for housing. Well, the housing provider should easily see that that is, an assistance animal within the meaning of the Fair Housing Act, and should not really need to ask for any more documentation or do anything further, to which they should simply grant that request. Another important thing to highlight in this area are internet verifications to support a request for an assistance animal. So over the years, there's been developed some websites out there that will claim to provide like a certificate of some kind to verify a disability-related need for an assistance animal or an emotional support animal. You have to approach with some caution, because HUD and guidance from case law will say that really a third party who's verifying a disability-related need really needs to be a third party that's actually familiar with that person and actually familiar with that disability-related need. Simply going to a website to provide some very limited information and get a certificate according to HUD's guidance may not be sufficient. Now, getting that verification from other third parties should actually be fairly easy. The requirements for verification are minimal. It just has to be a third party who has the ability to verify that disability-related need. It has to be a qualified third party, and there's many different people or service providers that could fall within that category. Could be a social worker, everything from a social worker who's assisting that person all the way up to a medical provider who can, provide a doctor's note. There's a lot of different ways to verify that. It's just a note of caution on just an internet website, website that's not actually familiar with that person's disability-related need. Another point to kind of pause on when it comes to emotional support animals or other types of assistance animals is unique animals. So think of animals that are not normally used as pets, such as normally you'd think of dogs or cats as potential support animals. Well, HUD's guidance does touch on what level of verification or inquiry should there be for unique animals, let's say like a snake or a guinea pig or other animals that aren't normally used as pets. So if the question though is examples would include the animal is individually trained to work or perform tasks that cannot be performed by a dog. If that's the case, then that would maybe be easier for that person to prove the disability related need. they would also be able to show the disability related need from information from a healthcare professional that confirms that allergies might prevent the person from using a dog or a cat, let's say, and without the animal, the symptoms or effects of the person's disability will be significantly increased. The individual seeks to keep the animal outdoors at a house with a fenced yard where the animal can be appropriately maintained. That might be another example of an instance where you're using a unique animal, but that's still appropriate to accommodate the disability related need. The point here is that housing providers and persons seeking accommodation requests definitely should not assume that unique animals are not allowed. They are. It's just that you would want to be able to additionally show that there's a need for that particular type of animal. That kind of burden normally is not there, obviously, for animals that are traditionally thought of as assistance animals. So the other thing to pause on when it comes to no pet policies and accommodations related to that is fees. So the housing provider cannot charge us a fee for that person to have the assistance animal. So let's say, like, normally the housing provider has a policy that's not necessarily no pets, but they normally charge an additional fee to allow that person to have a pet. Sometimes this will be an additional security deposit or a pet deposit fee. It could be arranged in a variety of different ways. But in any case, if the person needs the assistance animal to accommodate a disability, they cannot be charged any kind of additional fee, even if that's normally the housing provider's policy. So a lot of what we've talked about so far with accommodation requests are very specifically within the realm of the landlord-tenant relationships. And indeed, that's where they most commonly arise, is their accommodation from a tenant to a landlord or a person who is applying for a rental unit to that landlord, and they're making an accommodation request. But it's important to understand that accommodation requests can apply to all aspects of the housing industry. There's a lot of other examples where someone could make an accommodation request. So for example, let's say there's a local municipal zoning law that prohibits a ramp from being constructed on a house. Well, you can make an accommodation request to the zoning authority, to that municipality, that asks that they change that policy with regard to that house in order to accommodate the disability related need for the ramp. Let's say a hearing impaired person is purchasing a house and requests an ASL interpreter at the closing. That could be an accommodation request. A homeowner requests more time to complete a repair that is required by an insurance company in order to maintain coverage. That could be an accommodation request. A homeowner makes a reasonable accommodation request to a local zoning board to have an assistance animal that is normally prohibited in that jurisdiction. So some of those examples that I gave earlier, like let's say there's a miniature pony, or other instance may be like a pig or some other animal that that person needs for a disability related need, but the local zoning law at the municipality prohibits that in some way, or there's some other local law that prohibits having that animal. Well, that could be an example where that person could make an accommodation request as well. Well, let's say an homeowners association prohibits a fence from being constructed on the property, but the family has a child with autism, and the fence is needed to accommodate that family and the child with autism. Indeed, there's been cases that confirm that whatever the HOA rules may be, they are subject to an accommodation request, and the family certainly could make that kind of request to change the HOA's policies in that regard. So that wraps up that part of the presentation on accommodation requests. I'm going to actually hold on the questions for just a little bit to make sure we're good on time as we get into the reasonable modifications portion. So let's jump right in. We're going to go through the who, what, when, where, and how of reasonable accommodation or reasonable modification requests, excuse me. So under the law, housing providers must permit a person with disabilities to make reasonable modifications of existing premises if such modifications may be necessary for such a person's full enjoyment of the premises. Sounds very familiar, right, to the accommodation request. It's a very similar concepts, but it's a modification to the physical premises rather than to a policy. Examples of the modifications covered in the law include widening doorways to make rooms more accessible, installing grab bars in bathrooms, and lowering kitchen cabinets to a height suitable for persons in a wheelchair. And indeed, those are examples specifically provided in the federal regulations covering this issue. So modification requests can be made at any time. They do not need to be made at the beginning of the tenancy. It's worth kind of highlighting this specifically for modification requests because sometimes there's some confusion about that. The landlords sometimes believe that you have to wait, the person with disabilities should have saw the unit in advance and realized that they needed some modifications before they moved in. Well, that's simply not the case. Anyone could be disabled at any time. And just because the person waited to make the modification request until after they move in doesn't change the fact that they're entitled to a modification. So in other words, what grounds or where can the modification be made? Well, the premises is not limited to the interior of the person with disabilities unit. They can include lobbies, main entrances, and other public and common use areas of a building. And it applies to all existing premises, regardless of age. Now, that second point, let me explain that you may be aware that newer buildings have to be designed and constructed in a way that makes them more accessible if they're a multifamily housing complex. There's some rules about accessibility. Well, it's important to say that for modifications, though, those can apply to any type of housing unit. So if that, even regardless of when it was built, it may be a very, very old housing unit long before the Fair Housing Act was passed. It doesn't matter. You can still make a modification request for changes to that property. So why? Under the law, housing providers must permit a person with disabilities to make reasonable modifications of existing premises if such modifications may be necessary for such person's full enjoyment of the premises. The why here is to ensure that persons with disabilities are able to access that unit and fully enjoy it in the same way as anyone else. So let's pause for a moment too then on the question of what do you need to show to prove a violation of the law? Well, I'll read this, but you'll hear that it sounds very similar to the same elements that you need to prove for a violation of the reasonable accommodation standards that I discussed previously. So you must prove both the reasonableness and the necessity of the requested modification. In addition, an FHA reasonable modification plaintiff also must prove that she suffers from a disability, that she requested an accommodation or modification, the defendant housing provider refused to permit the modification, and the defendant knew or should have known of the disability at the time of the refusal. Again, a very similar standard to the one at issue with accommodations. Now, there's a number of different things where the rules become different though for modifications, and it's important to understand. So where otherwise the elements are very similar, this is where things start to diverge. First, most important thing to understand is that the person with disabilities generally must be the one that pays for the modifications. While they have the right to make the modifications potentially if they meet those elements, they still would have to be the ones that pay for the accommodation. And you just, let's say the tenant's moving into an apartment complex and they decided they want some modifications to accommodate the disability related need. Unfortunately, they're going to have to be the ones to pay for that. Unless, it's a very important exception, the housing is subject to Section 504 of the Rehabilitation Act. A housing provider is required to provide and pay for the structural modification as a reasonable accommodation unless it amounts to an undue financial and administrative burden or a fundamental alteration. If the property, again, is covered under Section 504, it's covered under Section 504 if it receives federal dollars. So it's a federally subsidized housing provider. They would have to pay for the modification request themselves. That's really important for a lot of folks that contact the Fair Housing Center may actually be folks who are using federally subsidized housing in some way, that modification. So it's helpful to keep that in mind because they would not have to pay for the housing for the modification to the property. So there are some other limitations too on modifications. The other is that the tenant cannot simply begin to do the work without first communicating with the landlord and indeed getting the landlord's approval. So the person making the modification must seek the landlord's approval before making modifications. House writers do not have an absolute right to reject proposed modifications or to select or approve who will do the work, but they are entitled to secure some protection against improper modifications and faulty workmanship. So under HUD's regulations, a landlord may condition permission for a modification on the renter providing a reasonable description of the proposed modification, as well as reasonable assurances that the work will be done in a workmanlike manner and that any required building permits will be obtained. So in other words, like, you've got to get this approval, make sure that the plans look good, that this is going to be done in a workmanlike way. There's got to be this discussion with the landlord before the modifications begin. Landlord may say, I don't need all that, go ahead with modifications, I trust you. But if they would like to have those kinds of confirmations in place before the work begins, the landlord is certainly entitled to those. Another important rule to understand for modifications is the potential for restoration requirements. So landlords may condition permission for a modification on the renter agreeing to restore the premises to their prior condition. So let's say whatever the physical modifications were, they might be required to restore them to their original condition if the person with disabilities moves out of the housing unit. The restoration requirement does not apply, though, in condominium and other non-rental situations. So in other words, if the person's the owner, then obviously in those kinds of situations, that restoration requirement would not exist. Here's a few more rules, though, on the restoration requirement. First of all, reasonable wear and tear is exempted from this concept. Restoration requirements can be imposed only on modifications to interior areas of an individual unit, not on public or common areas. So remember earlier, I said the premises where the modification could take place is quite broad. It could be the grounds or common areas, the main entryway. But the restoration requirement would only apply into that person's individual housing unit. And perhaps most importantly of all, the restoration requirement can only be imposed where it's reasonable to do so. So let's say, for example, a doorway is widened as part of the modification to a housing unit. It would be unreasonable to require that person to put the doorway back to a narrower, original condition. Why do that, though? Of course, anyone now is going to be able to more easily access that housing unit with a wider doorway. There's no apparent reasonable reason to require that it be restored to its original condition. And indeed, HUD regulations give that as an example of a situation where it would not be reasonable to impose a restoration requirement. Other things to keep in mind are the landlord may not increase for handicapped persons any customarily required security deposit. So just because you're making modification requests or otherwise, you can't increase the amount of security deposit. However, landlords in some limited circumstances may require tenants to make payments into an interest-bearing escrow account to ensure the funds will be available to pay for the restorations at the end of the tenancy. Now that must be for a reasonable amount of money over a reasonable period of time and may be required only if there's reasonably certain that they're necessary to ensure that funds will be available for the needed restorations. I think the takeaway here is very rare that I've actually seen a landlord impose the escrow requirement. It does come up sometimes that they want some amount of funds set aside by the tenant to ensure that the property will actually be restored to its original condition. So let's say what they're trying to foresee here is a situation where the tenant simply moves out without performing the restoration and is nowhere to be found Well, the idea is that the escrow account would help secure that performance of restoration. But it's quite often that this is not ultimately required because the landlord is concerned with the risk of whether it's really reasonable to demand the funds. And really many modification requests involve situations where anyone who lives in the unit afterwards can still benefit from those modifications. It's really not reasonable to even impose the restoration requirements anyway. So it's actually fairly rare that these escrow accounts or demands for escrow accounts come up, though it does happen sometimes. Our part 4, we're going to keep pushing forward through part 4, which may be the most important part, which is some practical suggestions for people making accommodation requests or for housing providers who are processing those requests. I'll try to push forward quickly so that we can get to some of the questions I see are popping up in the Q&A. So suggestions for tenants making accommodation or modification requests. So one of the most basic suggestions that we always make to tenants from the Fair Housing Center's perspective is submit things in writing, submit a letter, a form, or other documentation to your housing provider that clearly explains what you are requesting. Unfortunately, it's very common that tenants, maybe they just make the request orally or can't really prove or show that they've made the request. So this very basic initial step of starting to put things in writing is important from the requester's perspective. Include your name and contact information. Clearly, include a deadline. You want to have a date on the letter that indicates when it was provided. Save a copy of the letter, of course, for yourself so you can document that. The Fair Housing Center, as well as many fair housing organizations all across the country, have sample forms, and we actually even uniquely have an online tool on our website that will help persons making accommodation requests with creating a template letter for them, and we'll complete that for them with some basic information. I'm showing in your screen now just a very basic example of a great accommodation letter. It just gives some basic information, who the person is, references fair housing laws to be very clear, and also very specifically makes the ask for a closer parking space. So how do you request a reasonable accommodation or modification? So if your disability and the need for the accommodation or modification are obvious, the housing provider should respond to your request without requesting additional information. If your disability and the need for the accommodation are not obvious, the housing provider may require additional documentation to verify your request. So what I mean by that, let's say on that video that you watched earlier, the requester actually had a very apparent disability of a cochlear implant that you could see that they had clearly a hearing impairment. Arguably that's obvious, so if they had an accommodation related to that disability, that should be granted without further verification. Or another example is a person who's clearly using a wheelchair, then that person should not have to verify the existence of a disability if it's already apparent that they have that disability. But in situations where it's not obvious, then the housing provider may be able to ask for further verification of the disability. Now, verifications can be a letter, form, or other document provided by someone who's familiar with the tenant's condition. Typically, verification is provided by a doctor or therapist, but it could also just be a social worker, family member, or any qualified third party, as I mentioned earlier in the presentation. Documents should both verify, though, the tenant's disability and the disability-related need for the accommodation. In other words, the perfect verification letter will not only just say that they have the disability, but also confirm the link between the disability and the requested accommodation or modification. I'm showing you on your screen just a very basic template here of a verification letter. So it's from like a medical provider. It explains that this person has a relationship with them, they're seeing them, they can confirm that they have the disability, and they can also confirm the disability related need for the accommodation. By the way, we also have templates and other information about this specifically on our website as well at toledofhc.org. So making that accommodation request, we are going to be submitting that letter as I described. If applicable, include the verification from your qualified third party. A lot of times we suggest that persons making the accommodation request go ahead and include that letter with the verification letter with the accommodation request from the outset. That way everything is there. There's no delay. Include your name and address and contact information. Sign and date the request. Keep a copy, of course, for your records, as I emphasized earlier. And housing providers should respond to your request within a reasonable amount of time. But what if they request additional information? In most situations, housing providers are prohibited from requesting detailed medical records, inquiring about the nature or severity of the tenant's disability, requiring documents to be notarized, requiring that the qualified third party providing the verification agrees to testify in court. Believe it or not, see, these are some of the things that we've seen housing providers try to demand. There's no real reason to demand that the detailed medical records, but yet housing providers will sometimes try to demand that when they're considering an accommodation request or signing off to agree that you'll testify in court in some way. Those cannot be required. Just a basic level of verification is all that should be included. What happens if a housing provider denies the request? Well, if the housing provider denies the requested accommodation because it's not reasonable, they should still discuss whether there's an alternative that would effectively address the disability-related need. This is known sometimes as the interactive process. That term, interactive process, does not explicitly appear in the law, but there's a significant number of cases that reference this idea of an interactive process. And effectively, it's something that housing providers should assume that they're required to do. The idea here is that if the housing provider receives an accommodation request they feel like is unreasonable, or perhaps it's impossible for them to grant it, they should still have a dialogue with the requester to see if there's some other way that they can accommodate the person. And then if they still fail to do that, or if they just outrightly deny the request, then the person may file a complaint, the requester may file a complaint with the Ohio Civil Rights Commission, HUD, or even directly in court. There's no requirement that you first file with an administrative agency like Ohio Civil Rights Commission or HUD. The requester, if the request is unreasonably denied, if they meet those elements that we went through in detail, then they can proceed directly to court. As I said earlier, the term interactive process does not specifically appear in the law, but I should emphasize here that HUD's guidance explicitly does call for it in a joint statement between HUD and the Department of Justice. What they talk about there is the need to discuss the tenant's disability-related need for the requested accommodation and the possible alternative accommodations in the hope of negotiating an effective accommodation for the tenant that does not pose any undue financial and administrative burden for the landlord. Courts interpreting it include a few important decisions. So for example, in Jankowski, which I mentioned earlier, as well as if a landlord is skeptical of the tenant's alleged disability or the landlord's ability to provide the accommodation, it's incumbent on the landlord to request a documentation or open a dialogue. That's a great example, that example I gave of the person who was suffering from MS. If there's some question there, that's part of the interactive process, is to figure out how can I accommodate you? Is there any need for verification? This needs to have a dialogue and not simply outrightly demand or deny the request. It's important to note too that the Americans with Disabilities Act also has a mandate for an interactive process, and very often fair housing law can sometimes references the Americans with Disabilities Act as a point of influence in the way that we understand what's required under the Fair Housing Act. So again, even though interactive process, that phrase is not explicitly in the act, it's still something that I believe housing providers should assume is required. So it's something to think about if we're developing a reasonable accommodation modification policy. If you're a housing provider, we suggest that housing providers, especially landlords, develop a policy. Sometimes there's just the initial question is, should you develop any policy at all? And the question is definitely yes. That helps standardize things. It helps put things into forms that are then clearly processed. Your staff, the property managers, have a clear understanding of what they should do and what steps they should take if you train them on those processes. We have a significant amount of resources on this issue, again, on our website. If you go to toledofhc.org. One thing to keep in mind, though, as you're developing a potential policy, is that whatever the housing provider's policy may be, to like ask the person, please complete a form, process things in a certain way that the property managers are trained to do. Housing providers must give appropriate consideration to reasonable accommodation requests, even if the requester makes the request orally or does not use the provider's preferred forms or procedures for making such a request. So yes, we suggest that you have those policies and for standardized forms and train people. But at the end of the day, if that person makes an accommodation request, even if they don't complete your particular forms or comply with your particular policy, you still have to consider it. So as an example, a tenant in a large apartment building makes an oral request that she be assigned a mailbox in a location that she can easily access because of her disability-related need. The provider would prefer that the tenant make the accommodation request in that pre-printed form, but the tenant fails to complete the form. The provider must still consider the reasonable accommodation request, even though the tenant would not use the provider's designated form. That's a direct quote from HUD DOJ guidance. So again, as a point of emphasis, make sure if you're a housing provider, always be properly considering any kind of reasonable accommodation requests. At the Fair Housing Center, we've actually had a good number of cases that involve a housing provider. Let's say it's a local property manager, perhaps doesn't understand they cannot absolutely mandate those particular forms that their supervisor may have said that are required. Whatever the request is, they still have to consider it, potentially request verification as we discussed, but otherwise move forward with the interactive process and potentially granting the request. All right, so we made pretty good time and we're able to turn to some of the questions. Let's see what we have available here. One question is, what is the minimum in your opinion to meet the interactive process for reasonable modifications as encouraged by HUD? That's a really great question. Thank you for that. So the answer to that, one of the slides I emphasized earlier, is that accommodation and modification requests are very case by case specific. They're very fact intensive. That's because of the fact that the term disability has a broad meaning. The term reasonableness has a very broad meaning. There's a lot of different things that could be encompassed there. I know that it's sometimes hard for housing providers to not be able to have like a clear, concrete guidance of like how much time should I spend on this, or what are the very specific steps I need to take. Unfortunately, it does need to be very case specific. But the point is, I think the takeaway for housing providers is to try in good faith the best that you can to find a way to accommodate that person's disability-related need, to find some way to negotiate with that person over the request. The other thing I would suggest to housing providers and to tenants as well, people making the request, is to keep those kind of dialogue, that kind of interaction in writing, so you can show that you're responding in a timely manner, that you're proposing alternatives, and the tenant can show that they're getting back to the housing provider quickly to say, yes, I need this request, I'm willing to talk to you, but here's why I need that, etc. And it is very case specific, but at least that process, I think, could be applied in a uniform way. We've seen situations where that dialogue maybe sometimes will take place over a long period of time. The last thing I would point out, though, is just keep in mind that a long delay could amount to a denial of an accommodation request. In other words, what you wouldn't want to do if you're a housing provider is just use the interactive process as a way of just delaying things and not providing the accommodation. If that begins to appear to be the case, then it looks like it's simply a denial and therefore a violation of the act. Another question was, Mr. Thomas, would you please post the link to the video you showed in the case study? I would like to share it in our community of 30 parents of special needs kids in our area. Thank you. Yes, I can work on that. I'm going to go ahead and provide my contact information that's on the screen now. If you'd like to request something, specific materials, or ask more questions about anything that I presented, go ahead and send me email. Email is probably going to be the best way to reach me, or my direct extension is also on your screen now. Another question. Can a landlord deny a reasonable accommodation request for an assistance animal because the landlord's employee, maintenance person, is severely allergic to animals? The landlord claims maintenance person's allergy is a disability and she needs to refuse the accommodation request because of her employee's disability. That's a really great question. So one way we've seen this come up as well is, let's say there's generally no pets policy, but the person does have a confirmed disability related need for an assistance animal. Let's say there's another tenant that lives next door that may have a severe allergic reaction to the animal, and perhaps they have their own disability related need to not be near an animal. Or in this instance, it sounds like there's the hypothetical is with a maintenance worker who has a severe allergy. Well, the answer is again, this is very fact specific, very case specific question of like, how many units are in the complex? Is it possible for one person to move to a different unit where they're away from the other person who has this severe allergy, let's say? Well, what the housing provider should not do is simply deny the request, say, well, there's nothing we can do. There's another person who has an allergy, so the request is simply denied. What they should do instead is work with the person with disabilities, talk to them about some alternative way of accommodating them. The alternatives for accommodation, again, are be very fact specific. It depends on what that person may need or what could work for them. But some hypotheticals could include, let's say you would let the person out of their lease early without any penalties so that they can move if it's, the housing unit is not working out because of this issue. It could be a way of alternative accommodation is a zero penalty, allow them to break their lease early and move. All the way to, like, let's say they need to move to a different building complex that this housing provider also controls, where either the maintenance person isn't there or the other tenant who has a severe allergy isn't there. There's probably some way to accommodate that person's disability related need, and the effort should be made to do that. And they should also try to document that dialogue and document that effort to accommodate the person. Next question. My son attends a swim school, a private franchise renting space from a landlord that does not have accessible entryways. The school is located in a strip mall. Can we as customers request a modification to the doors, or does this law only apply to housing? Are there other ways we could make this request that would also help families with strollers, etc.? Okay, so yeah, well, that's a great question too. And to be clear, if it wasn't apparent from what we were talking about so far, is we're very specifically talking about the housing context. So that now the meaning of housing is very broad, but it generally would not include places of public accommodation that aren't dwelling units. So under the Fair Housing Act, when we talk about housing and the potential for reasonable accommodations and modifications, those apply to dwelling units. Dwelling units are a place where, as a residence, where you're probably going to return multiple times to live there. But it could be temporary in some way, but it's still, there's an intent to keep your possessions there, to return there in some way. Again, that definition is very broad, but that's the context that we're referring to. Now, the Americans with Disabilities Act, though, does apply to places of public accommodation, even if the Fair Housing Act does not. So you may want to think about what rights you have under the ADA in that particular example that you were giving. So for example, under the ADA, there may be requirements that this place of a public accommodation be made more accessible for persons with disabilities. I would probably need more information, and perhaps that's something to discuss further with the Ability Center if there's a place of public accommodation that's inaccessible for persons with disabilities. Another question, how would we find out if the housing provider is federally subsidized? Is there a list available online? These are all, by the way, so far really excellent questions. That's a great question. And actually, it's something that we sometimes struggle with as well. We need to try to confirm whether or not this housing provider is receiving some kind of federal subsidy. Unfortunately, it's not like a great easy way to do that. There's some sources available online. Sometimes it's easy to figure out with just Google searches whether or not this is a Section 8 project-based housing provider or not. Most often, though, the tenant themselves who's living at the property would know if their rent is subsidized in some way. So if their rent is subsidized down to they're only paying a portion of their income that's calculated, based on the income verification that they're providing, it's very likely that it's federally subsidized. Sometimes there's other programs that are not necessarily a federal subsidy that might not be included, but in affordable housing. But the vast majority of folks who have subsidized rent in some way, it's probably subsidized, at least in part, by the federal government. So that's usually the track that we use. Other ways to confirm federal subsidy include looking at real estate records. Sometimes I'll look at our local recorder's office and see what kinds of mortgages or other restrictions are recorded on the property to confirm that and whether or not the property receives federal funding in some way. I have an individual with their apartment complex denied him installing grab bars in the shower unless he removed them and made repairs to the shower walls upon moving out. Where does this fall? So that's a great question. So we were talking previously in the section about reasonable modifications. You might recall there's a section on the restoration requirements. And so if that person, let's say that person so far has a disability related need for the grab bar, if they're willing to either pay for it or show that the housing provider is federally subsidized, they may be able to install those grab bars, but the housing provider may be able to require that when the person moves out that they remove the grab bars and restore the bathroom back to its original condition. Now, there's still a question there about whether it's really reasonable to demand the restoration in that context. Well, if you think about it, is that really reasonable to have to remove grab bars? Anyone can use the grab bars. Anyone, future tenants, even if this person moves out, might benefit from their grab bars. So it may not seem reasonable to do that. But it may depend on, again, a very fact-specific question of, are the grab bars somehow in the way? Do they prevent other people who might be using the facility from fully enjoying the unit in some way? It's hard to imagine where that might happen, but this is very fact specific. It's just a question of, is it really reasonable to require that they remove the grab bars? Depending on the context, it may not be. So that might be a scenario where you could go back to the landlord and say, well, you might have the ability to have, require restoration, but in this instance, it's not reasonable to do that. Like, there's no reason to take grab bars out. Anyone can use those. So it's something to think about as you're advocating potentially with that landlord. The other person, Joe Muscoviak, asked, hi, George, I got this question from an attorney for a landlord. If a tenant makes a request to have snow shoveled or plowed to get to and from his unit in his car, and the landlord contracts out snow removal, is this a RA or RM? It is not a 504 property. So if it is an RM, the landlord could charge for the cost of snow removal. Wow, that's a really great question, because it's sort of right on the edge of, like, is this something that's a physical modification to the property, or is it something that's just a change in the policy? Well, I'm going to assume in this hypothetical here that normally they don't plow in the area where this person is requesting. But I would see that as a policy change and not a physical change to the property. You're really not making any kind of permanent physical change. I mean, I guess you're removing the snow, arguably. But I think that it would be a much stronger argument to say that's really just a policy accommodation and not a physical change to the property that would be interpreted as a modification. I know Brittany popped up, so we're running out of time here. Maybe I'll try to answer just one more question here. I'm just going to pick at random. So my apologies to folks who didn't get to ask their question, but my contact information is still on the screen here. I'll just grab one last question before we wrap up. Do apartment housing complexes have an obligation to, for instance, enforce handicap parking violations if the tenant has an accommodation for a disabled parking space? The answer to that is definitely yes. So the scenario is the person requested an accommodation to have a designated parking space or a placarded space. And let's say the housing provider, though, doesn't ever enforce that. Well, if that's part of the accommodation request, in an instance to have this space specifically for them, and then the housing provider doesn't do anything to enforce it or lets anyone park there, then yes, that could be a violation of the Fair Housing Act. One thing that that person may want to do to make their case very strong is that also specifically ask in an accommodation request that the housing provider enforce the policy regarding the designated space. That would set that person up very well to make that claim, to show that they very specifically requested enforcement of that policy as well, if that became an issue of, you know, just anyone parking in that space. And indeed, we've had those particular cases ourselves here at the Fair Housing Center and have been successful in those cases. So it looks like I'm just about out of time. Again, my contact information is there. Brittany or Katie, I don't know if you had any closing remarks, but I just want to thank everyone so much for your interest in this. It's a pleasure. We're happy to talk about this or provide future presentations on these issues as well.
Yeah, that was a really, really great discussion. I echo you. The questions were amazing. I thought they were really great questions and a great presentation. So thank you, George. Thank you to everyone for joining in. I just want to say that materials are on our webinar page. So the page that you went to register, if you scroll all the way down towards the bottom, you'll see a section that says materials, and that's like handouts, brochures, informational documents. And then below it, you will see presentations, and there are PDFs of slides for all the presentations. So we invite you to continue this discussion tomorrow at 10 a.m. with Sarah Pratt, Counsel with Relman and Colfax PLLC, and she will give an overview of design and construction requirements for housing under the Fair Housing Amendments Act. So we hope to see you then. Thank you everyone for joining, and have a great rest of your day.